Let's talk about armed robbery for a few minutes. And, well, most people know it under the euphemism taxation. But, it is armed robbery. That's what the facts tell us. And, well, we got some good news as far as the armed robbery this week. We got two tax things to talk about. And the first one I want to go to, let's see, where is it? Where is it? Where? Okay, there we go. This is I worked with Patti before. I reported in at the Libertopia show, and there's a video where the 2008 had been tossed out, and we got that in writing, which was nice. Again, this is from the State of California Franchise Tax Board. There is the official seal, and it is a notice of action, a withdrawal. Now, usually a notice of action is bad because their intention to steal your property, but this is a good one. And this is for 2010, so these are 2 years where they were attacking Patti. They have done the right thing, and they tossed it out. So we got this a few days ago. It was issued on the 7th. I got it a couple days ago in the mail, and it's a withdrawal. They sent it to me because, yes, I am the rep. I am the power of attorney. I'm the one who did the paperwork, did the calls on Patti's behalf. So, what they're saying here is based on the information you provided in your letter of protest, we canceled the notice of proposed assessment referred to above. You are not required to take any further action at this time. And if you see the arrow here, proposed 0. So they're not going to be trying to steal anything for Patti for 2008 and now 2010. So a big congrats to Patti for sticking it to the man, or at least standing up to the man. And really all we did here, I do the same thing. I just wanted to know, I called the agents and followed up in writing. Did the protest under protest because it's you don't get to challenge agency action. But all I did was ask the standard, what facts do you have to prove that the Constitution Code is applicable and that you have jurisdiction at all? And they're not able to tell me, and then we put that in writing, and of course, this was the result, a withdrawal. So big congratulations to Patti for that. The next one, really cool also. So we'll go here. If those have been following, Bill's come on the show, and this is the New Hampshire Employment Security. Oh, wow. Yeah, they're working to keep New Hampshire working, really. So the legal section, what happened was Chris Leonis initiated an attack against, he went to Bill, his place of business, and made threats and wanted certain information, wanted him to do certain things, and he can provide any evidence. And he said if Bill did not comply, he would be sending other agents down, ostensibly to get cooperation or compliance. Well, Bill challenged this, and that's when I started working with him. And this is where I spoke to Chris Leonis, and he admitted he had no facts to prove jurisdiction. He has since taken that back, but has not produced any facts. So there's supposed to be a hearing, and Chris wasn't there. None of the agents were there that are claiming that Bill has this obligation to this state of New Hampshire, these people calling themselves the state of New Hampshire. And the hearing officer didn't want to discuss jurisdiction, didn't want to discuss anything about evidence, refused to conduct a hearing, even if there were no witnesses there. Chris Leonis wasn't there. So we filed, so she just canceled. She just said, no hearing, you're refusing to participate. So what she did was she sent us documentation. We appealed that. I wrote a motion for reconsideration because there was no hearing, there was no evidence, of jurisdiction, there was nothing. The witnesses weren't there, nobody was cross-examined, and true to form, they rubber stamped it. Well, I didn't want this to be de-escalated because all they do is flippantly tell you, if you don't like it, you can appeal it. But it's our expense that's being taken up there. They're the ones. It's not costing them anything. So I decided to go to the higher up in the agency instead of having it appealed to to court or to another agency. So I went and I spoke with General Counsel, and let's see, her name was Maria Del Terrio, and I didn't think that it should escalate. There was no reason for it to escalate because there was no hearing at all. And why should Bill have to take more money and time and energy from himself to get this resolved when they didn't even have their little faux hearing? So she looked at, and this is all recorded, and like she says here, she says right here, I listened to the recording of the Administrative Hearing Committee of August 28th and spoken with staff members of New Hampshire Employment Security who have been involvement in the case. In doing so, I discovered that the documentary evidence upon which the NHES based its June 29th determination liability was not presented. And it says, of course, the rules require that. The rules also require such records, reports, summaries, and compilations of the department as may be material shall be made available for examination by the parties. Okay, which did not happen. They refused to give us anything. This is what I really like. Finally, according to the rules, all parties shall have the right to testify, to present witnesses, and to examine and cross-examine other parties and witnesses and department personnel with regard to the department records, reports, and summaries and compilations. Therefore, I am returning this matter to the Administrative Hearing Committee for a further hearing at which department personnel will be present and will introduce the documentary evidence upon which the determination of liability is based. Such personnel shall be available for cross-examination. The hearing will be held de novo. So a hearing on the merits. Of course, this was sent to me, Marc Stevens, and also copied to the Deputy Commissioner's Office. So I want to thank Maria Del Terrio for stepping in and correcting them, because what they had, again, like I mentioned, they had already rubber stamped this. Another lawyer at this office had already rubber stamped what the hearing officer did. She basically yelled at us for saying we were refusing to participate when all we were doing was questioning evidence and why the agents weren't there, even though their rules plainly allow for it. Now, I don't believe for a second that anything is going to be done to the hearing officer for refusing to conduct a hearing, but we can put in a complaint, since most of it's copy and pasting anyway. We already have the information there. But I doubt they're going to do anything, and I doubt the lawyer who rubber stamped it is going to have anything done. Either it's not going to cost them a dime, but it certainly is costing my client money, which they don't care. So this, I think, is significant because it's from the legal section. They reversed everything. We did not have to appeal it. Finally, someone listened to us and did the right thing. Now, it would be nice if they just looked at this part and said that the personnel shall be available for cross-examination, and they do like they've done before, like what the Franchise Tax Board did, say, and withdraw without the hearing. See, there was supposed to be a hearing. So they can withdraw, and we've had it done where they could withdraw without a hearing. That's what I'd like to see here. But either way, if Chris Leonis, who made the determination back on June 29, 2012, if he believes that he does have facts to prove that the Constitution and Code are applicable and that there's jurisdiction over Bill, well, he's more than welcome to have the thing set for a hearing and show up like he should have done the last time. I'm Marc Stevens, and there'll be more information on at marcstevens.net, and we'll be discussing this on the show further. So.